In the previous lesson, we spent a little bit of time talking about the idea of the purpose trust for the maintenance of animals, specifically the maintenance of private animals. We noted that this is both an exception to the non-charitable status rule on the one hand, but it is also an exception to the beneficiary principle on the other, given that there isn't a clearly identifiable beneficiary, but that the trust itself would not satisfy the charitable purposes element because it would not be for public benefit because it's for the maintenance of private animal usage. And so we conclude that this represents one of the anomalous exceptions to the beneficiary principle, the beneficiary rule, which is, of course, what the whole idea of the non-charitable purpose trust exists to examine. This lesson is going to talk about another of the anomalous exceptions to the rule, this being, of course, the idea of the purpose trust for monuments. The previous lesson, like I said, examined the first anomalous exception to the beneficiary principle, the creation of the trusts for the purposes of benefiting specific animals. This lesson, as I've just mentioned, is going to talk about the second of the anomalous principles, the anomalous exceptions, the idea of trust being created for the upholding of monuments. So first things first, it should be important to note that we have to think about the charitable versus non-charitable status for a little bit. If a trust is created for the purposes of maintaining the upkeep of, for example, a church or a mosque or a synagogue, something of that kind of religious sentiment, then it would simply just be considered a valid charitable trust. Because, of course, a religious institution like a church or a synagogue or a mosque is considered to be a public institution. Therefore, the maintenance and upkeep of such a building would be for the purposes of a public benefit. And it would, of course, fall into one of the heads of charity under the Charities Act, which is obviously the advancement of religion. So that would just clearly be a charitable trust. It would not adhere to the beneficiary principle, but it would be valid because it would be charitable, because it would be for a purpose that is charitable. What if, however, we were not talking about the upkeep of a church or a religious institution, but we were talking about the upkeep of an individual monument specific to an individual person, let's say a grave or a gravestone? Would this therefore be the same kind of trust? Well, you can see here already that whereas a trust for the creation of or for the upkeep of a church is clearly charitable because it has a public benefit, there isn't necessarily a public benefit for a trust that is created for the maintenance of gravestones, a specific gravestone of a specific individual who has died. That is not public benefit because and therefore it is not charitable. This is therefore a non-charitable trust, and it is still nevertheless a non-charitable trust which has a purpose, not a beneficiary, which therefore means it represents another anomalous exception to the beneficiary principle. Again, the key distinction here is the requirement of public benefit. There is no beneficiary if we talk about the upkeep of a church or a religious institution, but this is acceptable and this is fine because there is public benefit and it falls into one of the heads of charity, so it could be considered just a valid charitable trust. This here also doesn't have a beneficiary if it's, for example, a monument or a gravestone, but it also doesn't have a public benefit. Therefore, it is not a charitable trust. Therefore, it falls into the anomalous exceptions of the beneficiary principle. Let's look at some case law that illustrates this point. The case here from 1932 of Re Hopper was a case which concerned the creation of a trust for the purpose of the upkeep of family graves and monuments, as you can probably imagine. So let's think about it. How does this operate? The High Court held that, in fact, it was indeed considered to be a valid trust. It did indeed represent something of an anomalous exception to this principle, but it was imposing a limitation on the time period in which this trust can be maintained. Essentially, the High Court concluded that such a trust of this nature would only be valid for 21 years, after which the surplus money, the residue estate, would be able to be given to anyone who may be entitled to any residual estate. That's a very interesting point. That's a very interesting element that is added and is sort of attached to the end of this particular conversation. In addition to this, we have another case of Riedercott from 1959. Again, this is a case which illustrates the limitations on the creations of these trusts. Remember what I said in a previous lesson looking at purpose trusts, that one of the things the courts have been particularly clear in their illustration is that fundamentally the creation of these trusts are subjected to quite strict scrutiny. They're subjected to strict scrutiny on the basis that they do represent an exception to an uncomfortable exception, fundamentally, to the ordinary understanding of the ways in which these trusts operate. So they represent an anomalous exception because, of course, they do not adhere to the beneficiary principle and they do not adhere to the charitable status principle either. And so this case illustrates the limitations on these trusts. The case itself concerned a trust which was established by the testator for the purposes of providing some useful memorial to himself. That was the sort of seen to be justification. This was a generalized and quite a vague declaration of purpose, and so as a result of which, the Court of Appeal held that it did not fall into the anomalous exceptions, because it also did not have a clearly defined beneficiary. And what this case does is illustrate the hesitancy that the courts have had in the past when it comes to making determinations as to the expansion of these anomalous exceptions rules. They say here, quote, "No principle perhaps has greater sanction or authority behind it than the general proposition that a trust by English law, not being a charitable trust, in order to be effective, must have ascertained or ascertainable beneficiaries." So essentially what this case illustrates is the sanctity of the beneficiary principle on the one hand, and also the hesitancy that the courts will have when it comes to essentially providing derogation to the beneficiary principle on the other, making it very, very clear that there cannot be this kind of this derogation from such a beneficiary principle. And so as a result of this, it must be the case that it clearly falls into a non-charitable purpose trust in order for it to be able to derogate from the beneficiary principle. A case of this nature was just too vague a declaration of purpose to be able to fall into any kind of anomalous exception.